Welcome to Influential Entrepreneurs, bringing you interviews with elite business leaders and experts, sharing tips and strategies for elevating your business to the next level. Here's your host, Mike Saunders.
Hello and welcome to this episode of Influential Entrepreneurs. This is Mike Saunders, the Authority Positioning Coach. Today we have back with us Randi Karpinia, who's the CEO of Sagacity Legal, and we'll be talking about how to understand worldwide patent strategies. Randi, welcome back to the program.
Thank you. So glad to be here again.
Yeah, so I know we've talked before about patents and, the considerations, but now we start expanding our reach to worldwide, global, international. So talk a little bit about when the need is for worldwide patent strategies, because sometimes some patents might not need that, but in some cases, we now need to move to worldwide.
Yeah, exactly. So, this, as you know really well, the entire business arena has gone digital, has gone online, and has gone international. So whereas, years ago, an inventor would create, a new kind of soap. I just made that up. And they would open up a soap store and they would sell their soap, and it would be in one country, and they would just protect that product in that country. But that doesn't always work today, in that you might be selling online. So many of my clients are selling on Amazon these days, right? They develop the product. They may be manufacturing the product in another country like China or Europe, and they may be selling to people all over the world. And having only, for example, a United States patent, there are a lot of examples or a lot of situations where they won't be protected.
Now, you said selling worldwide. Is that a requirement of now considering needing a worldwide patent? And the reason I'm thinking of that is, if you put a product you make on Amazon, you don't know where people are located. You never know who buys your stuff, because Amazon fulfills it most of the time. But if you were to set up a website and you start selling internationally, is that the trigger that would make you think maybe now I need worldwide protection? Because if you're just selling in the United States in stores or maybe on your website and you have no need to go international as far as selling, do you need to consider a worldwide patent?
Mm-hmm. And I wanted to make sure and clarify one thing. There isn't actually one worldwide patent. There is not such a thing. I have people come to me all the time and go, can I just get a worldwide patent that handles all, 195 countries in the world? And the answer is no. So I did want to clarify that.
Yeah,
there is not
that'd be like a blanket.
A worldwide patent.
Yeah, like an umbrella patent.
Yeah. Well, and it's a great idea, and we'll talk later about some things that kind of get us towards that, but It doesn't exist. So it becomes just like everything we've talked about when it comes to intellectual property. It's very much around a risk versus value versus budget, because, for example, filing a patent application in 100 and something countries, I don't have that kind of pennies. I think most people, it would be exorbitant. Yeah. So deciding where your customers are, where your competitors are, and making very strategic decisions early on, because unfortunately these are decisions you have one moment, which is 12 months from when you file your first patent application. That's all you got. So it's very, very difficult, because you have to make very early decisions on where am I selling, where are my competitors, where am I manufacturing, and strategically determining which protections, which countries you're going to work to protect is very, very important. And so I'll give an example. Say you have a granted patent in the United States, and you decided only to do the United States because you're a startup and you only have so many funds and it was just too much. And you thought, well, my market is mainly the United States. And you're selling, as you had said, on a website. So you're thinking most of your clients coming to your website to buy that product, to see that product, are from the U.S. So say someone from China, I'm not picking on China, I just picked it as an example, sees it and is able to reinvent it or re-engineer it and come up with a competitor. And they say, okay, fine. I'm going to sell it in Asia and Europe. I'm just going to stay away from the U.S. since you have a patent there.
Mm-hmm.
You can't do anything if you have no protection outside the U.S.
So without getting into, well, I guess one question would be, if I was an inventor and I heard you say that and I had a patent about to get granted in the United States, I would say to you, Randi, there's hundreds of countries. What in the world do I pick? The top 3, the top 10? What do I pick? Because any country, like you said, anyone from China could see this and do the knockoff. Well, someone from Germany could do the same thing. How do you know which countries that you should move forward on looking at getting worldwide patent, focus in?
And it's a very, very difficult question, and each industry is different, right? So inventors ask me exactly that question, especially, if they're starting to get some traction. So again, I'm going to repeat, it would be way prior to even knowing. You have to make this decision before you even know if you're going to get a granted patent, because again, you have 12 months from when you file. So most times with patents, you haven't even seen an examiner yet. You have no idea if you're even going to get a grant, right? So one option is to say, and it goes, again, it all ties, as we've talked before, into, marketing and knowing your market. So one option is to say, okay, I kind of know where my competitors are. So that's where the infringement might be. I kind of know where my market is because I've done all that. So I'm going to pick like the top 3 countries. It's almost like throwing on a dartboard, right? Okay, from all of my research, this is what I believe, and these are the countries I'm going to file in. But the good news is...
Have you ever heard of the BRIC countries? BRIC?
No, tell me what that is.
It's just, in marketing, it's like the BRIC countries are Brazil, Russia, India, China, and I don't know what the qualifications are why they would be the ones that would have the acronym BRIC, but it's basically the biggest ones that are the most viable. So potentially, if you took that along with your known competitors, because you should know your market and your competitors, maybe that's a good overlay to say, okay, that could be a first step.
Very, very possible. Yeah, I hadn't heard of that before. So Brazil, yes, a big market in South America. China, always a big market, and also where a lot of manufacturing is done and a lot of competition. India, obviously, very large. So, those that is a possibility. Russia right now, for obvious political reasons, we're not filing there. There's some issues there, but normally I'll give you kind of an example. So if a client is in the clothing industry, they'll tend to want to be in Europe. Same with software. Software tends to want to be in Europe. So there are, most U.S. inventors want Canada, Mexico, like you said, maybe Brazil. Okay. So those are exactly, you go through in your head, what is the best strategy and where do you believe you'll be? And then the good news is I didn't fib, but I kind of made it sound like you have to pick those countries at 12 months. There's actually some strategies and some placeholder stopping time that is available that gives you some extra time. And we can talk about some of those options, which will delay making the decision and still keep you in the running.
And that might be helpful for the people that say, I don't want to feel constrained with 12 months. My product hasn't even gotten off the ground yet. But if you had a strategy where we can kind of put the foot in the door and to buy yourself some more time, then you can let things develop and materialize. And then all of a sudden it's like, oh, now I have a clearer picture of this country, that country.
Exactly. And in almost every case, what I'm going to talk about now is what I advise my clients. The only time that we would pick individual countries early is if we just knew at 12 months that this product is only going to be manufactured here and sold here, and there's no other competition, right? So I can't think of an example, but then, yes, you could pick your countries immediately and meet the 12, at the 12 months. But very, very rarely do I do that. I can't even in my memory remember the last time, because we have other options. And those options, like I said, are delay tactics in a way, but are also helpful. And there's one main that I normally kind of vote for, but there are two, so I just want to bring it up. So we talked about direct into the country. There are treaties and agreements throughout the world with different countries agreeing to kind of handshake about the patent examination process. There's still no one patent that you can get granted in multiple countries, but there are these treaties and agreements. And some of them are regional. For example, there's an EPO agreement where you can buy yourself some time for all Europe countries, with the exception now of UK, which because of Brexit. But so that can buy you time. If I really want to protect Europe, but I don't know exactly which countries yet. Is it Italy, Spain? I just don't know. So the regional agreements and the regional patent applications are a good way if you know which region, but you don't know the specific countries. But the most often used by me with my clients, because many are startups and new inventors, is what's called a PCT application, or a Patent Cooperation Treaty.
Okay.
And I know that's a lot, but what that is basically an agreement. So remember, there's like 195 something, I think that's how many countries there are. Well, 155 of them have agreed to this treaty. So they literally have signed a treaty. And we can talk about the benefits, but it gives you that, it buys you some time. You still have to file before the 12 months, but you don't have to pick your countries for 30 months.
Okay.
You've just bought yourself another year and a half or more. And the theory is a year and a half later, you will have learned more, right? You'll know better what's going on with your product. Now, I will tell you, I just had a call on Friday with a client who's at that point, and they can't believe how quick the time went by.
Yeah. Oh,
like, we're not ready to pick, but again, with everything, the deadlines are the deadlines. So
and
we
you're
can buy
closer
time.
to picking than you were 30 months ago, 12 plus 18.
Exactly.
So it is what it is. You better realize that's the date. It bought you an extra 18 past the 12. So be planning accordingly.
Exactly. So the PCT doesn't just delay. What's really cool about it, and this is the same if you go regional, is those offices actually examine the patent application. So you get a consolidated review of your application, and usually even way before you get, for example, if your first file was US, usually way before. So and you can make changes to get closer to an allowable, grantable patent before you go into the other countries, which means you just saved yourself a whole bunch of time and money when it goes into the other countries, because it's already been examined by somebody that
So it's
they
not
have
just an
agreed
application.
on.
It's almost like a little hybrid.
Yeah.
It's not just the application, it's an application plus a little bit more.
Yeah, it gives you the ability. It's an application that gets examined, which to me is so valuable because if you wait for say you go into 10 countries, that's 10 examinations, that's 10 examiners, that's 10 replies you have to do. It can get really time consuming and pricey. But if you do something like a PCT or even like a Europe regional, then most of the countries will just go along with what that examiner said. Because, basically they've done the work for them, right? Save them time.
Is that the better
them
step?
having to do it.
Let's say that you knew you wanted to file in China, Brazil, and India as an example. Would you just, if you knew that, would you just go file in those 3 countries, or would it be more helpful to file this PCT ahead of time, get your ducks in a row, knowing that they're going to do a little bit of pre-work, and then when you do file in those 3 countries, they're going to kind of refer to this PCT application? Is that a helpful strategy, or if you knew you're going to go to these certain 3 countries, just go do that right away?
It's so business specific.
Yeah.
I prefer the consolidated examination, and I also, and again, every business is different, and I never question business owners, but what you think was promising may change. You're running a business from year to year. You just don't know what's going to change. So you think you're pretty sure, high percentage sure that those are your 3 countries. But what if something changes? What if all of a sudden someone pops up in a different country as a competitor or as a possible, partnership for this great new customer for you, and you had not previously done anything? The 12 months are gone. You're done.
So that PCT almost is like the blanket. It's like an initial blanket. Yeah. It gives you a little bit of time to consider, buys you that extra 18 months. And then also it leaves some options open, because if you thought you were going to file in these 3 certain countries, but if the 4th one or 5th one or 6th one popped up, now if you had filed the PCT, that gave you that latitude.
Absolutely. I'll give you an example. I have a client that has a portfolio, so we've been filing, and they have gotten a number of granted, and so now they're starting to look at licensing out their portfolio, which is one way people use patents. Not everybody, builds a product, right? And out of the blue, a country has popped up that they hadn't been thinking about, because a brand that is in that country has moved into a new arena, and that new arena is where their patent portfolio is. So 6 months, a year ago, that country wasn't even on the radar for them. They had identified where they wanted to target their, to offer the licenses. And now all of a sudden there's this really great possibility. If they had picked their countries earlier, they'd be in trouble right now, right? They wouldn't be able to. Now their whole strategy has changed where that's their target.
That's a great point. So if you have, I think that the big takeaway here so far is, if you've got the great invention idea and it's patentable because you've done some of the preliminary work with you, when do you know that you need to go international? Well, it's case by case, business by business. But when you do know that, this PCT gives you a little bit of blanket latitude, keeps your options open, buys you some more time. Is there another strategy beyond the PCT that would be similar?
So there isn't. The only other strategies are, like I said, going regional. So you could pick multiple regional and do the same thing. And by the way, you can even go from PCT to regional. So there's that option. But there's no other option that gives you the breadth of 155, 156 countries. So it is very business focused, and how well you know what your business is going to do. I will say that I've seen, many inventors, many businesses who just do not file internationally at all. They are happy with just having, one, whether it be in US or Germany or wherever. And I've also seen that strategy hurt them, a year, 2 years, 3 years later.
Yeah, because you assume that, well, I'm fine with just the United States. If someone came along, I'm not going to fight it, but you could have some, the next best thing since sliced bread and be missing out on opportunity.
Exactly. And as we said at the beginning, the world is so small these days with technology and everything being so digital. And the one thing I didn't mention is if you file a U.S. patent, it's secret for 18 months. But after that 18 months, it's published, which means the whole world can look at your invention. And as part of filing a patent application is something called enablement, which means you tell the world how to make it. So
you gave them the recipe.
You've basically given the recipe to your competitors. Wow. 18 months after you filed your patent application.
Yeah. Yeah, then the cat's out of the bag, huh?
Exactly. So, again, I think we talked in other shows, when you get a patent, and it's not just in the U.S., it's a contract, you tell the world how to make your invention for like in the U.S., a 20-year monopoly. Each country is a little different. So you're getting a monopoly to make, use, and sell wherever you've gotten the patent in exchange for telling everyone how to do that. Well, again, when you think about it that way, you've also just, if you don't file where your competitors are, you don't file where you're selling, then you just handed especially if you become very successful, you've just handed someone else your recipe.
Yes. Well, as with anything, there are risks, and you need to know them going in, and you need to understand your options. And that's where working with, or at least getting advice from someone like yourself comes in, where you could say, tell me what you're looking to accomplish. Let's see what the options are internationally, globally, worldwide, and if this PCT would be a benefit to you. And if it is, then here's some consideration. So where can someone that is listening to this that goes, oh, wow, I thought I would ignore it. Well, but now I'm understanding there could be some risks to ignoring international. Well, I thought that I could just file one thing and it covers the whole, globe. Nope, that doesn't happen either. But if someone is wanting to get your input and advice and learn a little bit more about working with you, do you have any educational content on your website, or do you offer a consultation? What's the best way they can reach out and connect with you, Randi?
Yes and yes. So I have a blog on my website, sagacitylegal.com, and there's a search on the blog where they can just put in patent. And there's actually a number of posts about worldwide patent protection and other patent protections. And also, I do offer anybody a free legal consultation because I love chatting with creative inventors and learning more about how I can help them, and that anyone can get on my calendar at meetwithrandi, RANDI.com. And I also have a YouTube channel, Attorney Randi Karpinia, where every couple of weeks I publish some new videos. So if you prefer to listen or watch a video, you can go to YouTube. If you prefer to read, you can go to my blog, or if you want to chat, just get on my calendar.
Well, Randi, thank you so much for coming on. I'll make sure to have the link to your website in the show notes, and I appreciate you giving us a little bit of insight on these worldwide patent considerations.
Thank you so much. Always a pleasure.
You've been listening to Influential Entrepreneurs with Mike Saunders. To learn more about the resources mentioned on today's show or listen to past episodes, visit www.influentialentrepreneurssradio.com.